Severing an adult relationship in England and Wales is an exercise in strict procedural mechanics. The process no longer functions as a search for moral fault. The historical system of proving behavioral faults or adultery has been removed from the law. To understand this modern framework, we look at the foundational statutes. For opposite-sex and same-sex marriages, the Matrimonial Causes Act 1973 remains the primary governing text. Civil partnerships, meanwhile, are governed by the Civil Partnership Act 2004. Although these relationships originate under different acts, the Divorce, Dissolution, and Separation Act 2020 aligned their procedures into a single stream. Examining these statutes shows how the 1973 and 2004 acts provide the basis for the relationship, while the 2020 Act dictates how it ends. This means both marriage and civil partnership are now pushed through the exact same procedural funnel. All of these cases are issued in the family court, a unified national venue that centralizes jurisdiction and the allocation of cases. Mastering this statutory convergence is the baseline requirement for navigating the modern family court system. The life cycle of a relationship dissolution is now dictated by a chronological timeline. For the first 12 months of any marriage or civil partnership, initiating formal dissolution proceedings is strictly and legally prohibited. This one-year bar is absolute, as established under Section 3 of the 1973 Act and Section 41 of the 2004 Act. Once that first year has passed, there is only one ground for divorce or dissolution, that the relationship has irretrievably broken down. Practitioners no longer need to rely on the traditional 5 facts to prove that breakdown to a judge. Applications can now be submitted jointly by both parties or solely by one individual. These specific effects of the 2020 Act confirm that a simple statement of breakdown is sufficient without the need for additional evidence of fault. Even the professional terminology has shifted. The person starting the process is now referred to as the applicant rather than the petitioner. Contesting an application is now limited to specific legal challenges regarding jurisdiction, the validity of the marriage, or whether the marriage has already ended. This renders the initial application a streamlined administrative gateway rather than a platform for litigation. Modern practitioners manage the majority of this process through a professional digital online portal. The first major milestone in this digital timeline is a mandatory 20-week cooling-off period. This clock starts running the moment the application is issued by the court. After these 20 weeks have elapsed, the process moves toward the middle stage of dissolution. At this point, the court pronounces a conditional order. This confirms that the legal requirements for dissolution have been met. However, another pause follows. There is a subsequent wait of 6 weeks and 1 day before the next step can be taken. This window is used by practitioners to resolve financial remedies or child arrangements before the marriage is finalized. While a conditional order confirms the divorce can proceed, only the final order creates a permanent legal change. When the final order is pronounced, the marriage or civil partnership is legally extinguished. The formal application for this order marks the end of the procedural timeline. Strategy in a family law case is now dictated by the requirements of these 2 specific statutory wait periods. For clients who need legal boundaries but wish to remain married, judicial separation exists as a distinct alternative. This path is authorized by Section 17 of the Matrimonial Causes Act and its equivalents in the Civil Partnership Act. Unlike divorce or dissolution, an application for judicial separation can be made within the first year of the relationship. While it terminates the duty to cohabit and allows for most financial orders, the parties cannot remarry, and they cannot access pension-sharing orders. This remains a functional route for clients with religious or personal objections to a final divorce. Judicial separation provides the necessary structural alternative for clients who require legal protection without a final severance of the relationship. Looking at the complete procedural life cycle shows a single, unified model for relationship dissolution. Whether the case involves a marriage or a civil partnership, the journey follows the gates established by the 2020 Act. The role of the practitioner has changed. The focus is no longer on investigating behavioral fault, but on managing the process and its mandatory timelines. Navigating the intersection of these 3 acts is what defines success in the modern family court.